The limited issue for the consideration of this constitution bench only relates to the scope of legislative and executive powers of the Centre and NCTD with respect to the term services. That is to say, whether the NCTD or the union government has legislative and executive control over services. Then we deal with the constitution bench of 2018 and say, we are unable to agree with the view of Justice Bhushan in the 2019 split verdict. As indicated previously, the majority decision in the 2018 Constitution Bench judgment rendered a broad interpretation of Article 239 AA3A to provide NCTD with vast executive and co-extensive legislative powers except in the excluded subjects. A combined reading of the majority opinion and the concurring opinions of Justice Chandrachud and Justice Bhushan indicates that the phrase "insofar as any such matter is applicable to union territories" does not restrict the legislative powers of NCTD. While the 2018 Constitution Bench judgment provides sufficient clarity on the interpretation of the phrase "insofar as any such matter is applicable to union territories," we find it necessary to deal with the arguments made by the Union of India that the phrase must be read in a restricted manner to limit the legislative power of NCTD on certain subjects in addition to already excluded subjects in List 2. Article 239 AA3A confers legislative power to the NCTD. However, it does not confer legislative power to NCTD over all entries in List 2. Article 239 AA3 provides multiple safeguards to ensure that the interest of the Union of India is preserved. First, subclause A of clause 3 removes 3 entries in List 2 from the legislative domain of NCTD. It provides that NCTD shall not have the power to enact laws on matters with respect to entries 1, 2, and 18 of the state list, and entries 64, 65, and 66 of that list insofar as they relate to the said entries 1, 2, and 18. Second, subclause B of clause 3 clarifies that Parliament has the power to legislate on any matter for a union territory, including on subjects with respect to which NCTD has legislative power under Article 239 AA3A. In other words, Parliament has a plenary power to legislate on a subject in any of the 3 lists of the 7th schedule for NCTD. Third, it provides that where there is a repugnancy between a law enacted by the Legislative Assembly of NCTD and a law enacted by Parliament, the latter will prevail. The law enacted by the Legislative Assembly shall, to the extent of the repugnancy, be void. Unlike Article 254, which provides for the overriding power of Parliament only on subjects in the concurrent list, Parliament has overriding power in relation to the NCTD over subjects in both List 2 and List 3. Fourth, the second proviso to Article 239 AAC provides that Parliament may enact at any time any law with respect to the same matter by including a law adding to, amending, varying, or repealing the law so made by the Legislative Assembly. Fifth, under 239 AA7A, Parliament may by law make provisions for giving effect to or supplementing the provisions in the foregoing clauses of 239 AA, and for all matters incidental and consequential thereto. The article stipulates that such law shall not be deemed to be an amendment of the Constitution for the purposes of Article 368, which deals with the power and procedure to amend the Constitution. Thus, Article 239 AA3 balances between the interests of NCTD and the Union of India. Article 239 AA expressly excludes entries 1, 2, and 18 of List 2 from the ambit of the legislative competence of the Legislative Assembly. 239 AA also stipulates that the legislative power of NCTD is excluded with respect to entries 64, 65, and 66 of List 2, insofar as they relate to entries 1, 2, and 18. Entry 1 deals with public order, entry 2 deals with police, and entry 18 deals with land. Then we explain the entries. Thus, the exclusion of entries 64, 65, and 66 to the extent that it relates to entries 1, 2, and 18 from the legislative competence of NCTD indicates that the governance structure envisaged in Article 239 AA for NCTD was only to exclude specific entries from its legislative competence. To read the phrase insofar as such matter is applicable to the Union territories as introducing an implied exclusion of the legislative powers of NCTD with respect to certain other entries would be contrary to the plain meaning of the provision. Article 239AA establishes the Legislative Assembly for NCTD. The seats in the Legislative Assembly are filled by a direct election from the constituencies of NCTD. The Legislative Assembly of NCTD embodies the constitutional principle of a representative democracy similar to the Legislative Assembly of the state. The members of the Legislative Assembly of the NCTD are selected by the electorate of Delhi to represent their interests. Article 239AA must be interpreted to further the principle of representative democracy. To interpret the phrase insofar as any such matter is applicable to Union territories in a restrictive manner would limit the legislative power of the elected members of the Assembly. The members of the Legislative Assembly have been chosen by the electorate to act in their stead. Thus, the legislative competence of NCTD must be interpreted to give full impetus to the will of the electorate. Then page 53. The principles of democracy and federalism are essential features of our constitution and form a part of the basic structure. Federalism in a multicultural, multi-religious, multi-ethnic, and multilinguistic country like India ensures the representation of diverse interests. It is a means to reconcile the desire of commonality along with the desire for autonomy and accommodate diverse needs in a pluralistic society. Recognizing regional aspirations strengthens the unity of the country and embodies the spirit of democracy. Thus, in any federal constitution, at a minimum, there is a dual polity. That is, two sets of government operate, one at the level of the national government and the second at the level of the regional federal units. These dual sets of government, elected by we the people in two separate electoral processes, is a dual manifestation of the public will. The priorities of these two sets of government, which manifest in a federal system, are not just bound to be different, but are intended to be different. While NCTD is not a full-fledged state, its legislative assembly is constitutionally entrusted with the power to legislate upon the subjects in the state and list and concurrent lists. It is not a state under the first schedule to the Constitution, yet it is conferred with power to legislate upon subjects in List 2 and 3 to give effect to the aspirations of the people of NCTD. It has a democratically elected government which is accountable to the people of NCTD. Under the constitutional scheme, NCTD was given legislative power which, though limited in many aspects, is similar to states. In that sense, with the addition of Article 239AA, the Constitution created a federal model with the Union of India at the center and the NCTD at the regional level. This is the asymmetric federal model adopted for NCTD. While NCTD remains a union territory, the unique constitutional status conferred upon it makes it a federal entity for the purpose of understanding the relationship between the Union and the NCTD. A combined reading of Articles 73 and 162 of the Constitution indicates that the Union has exclusive executive power over entries in List 1. The states have exclusive executive power over entries in List 2. With respect to List 3, that is a concurrent list, the Union shall have executive power only if provided by the Constitution or by a law of Parliament. The states shall have executive power over the entries in List 3. However, if a central legislation or a provision of the Constitution confers executive power to the Union with respect to a List 3 subject, then the executive power of the state shall be subject to such law or provision. The executive power of the Union in a state over matters on which both states and the Union of India can legislate, that is the concurrent list, is limited to ensure that the governance of the states is not taken over by the Union. This would completely abrogate the federal system of governance and the principle of representative democracy. It is with this objective in mind that the members of the Constituent Assembly thought it fit to limit the executive power of the Union in a state over matters on which the state legislature also has legislative competence. The principle in Articles 73 and 162 would equally apply to the scope of executive power over matters which are within the legislative competence of both the Union and the GNCTD. This is because the objective of the provisions is to limit the executive power of the Union in the territorial limits where there is an elected government of a federal unit. Both Parliament and the legislature of NCTD have legislative competence over List 2 and List 3. For the purposes of NCTD, both List 2 and List 3 are concurrent lists. Thus, the delimitation of executive power between Parliament and the government of NCTD with respect to entries in List 2 and List 3 are guided by these principles. Both Parliament and the legislature of the NCTD have the power to enact laws with respect to List 2, subject to the caveat that entries 1, 2, and 18, and entries 64, 65, and 66, inasmuch as they relate to entries 1, 2, and 18, are carved out of the domain of the Legislative Assembly of GNCTD and List 3. The executive power of NCTD shall extend to all entries in List 2 and List 3, other than those entries which are expressly excluded in Article 239 AA3. Such power shall be subject to the executive power of the Union through the Lieutenant Governor only when the Union has been granted such power by the Constitution or a law of Parliament. Therefore, the executive power of NCTD in the absence of a law by Parliament shall extend to all subjects on which it has power to legislate. It was held Then we cover Rule 46 of the rules, and we say the rule provides that the Lieutenant Governor shall exercise such powers and functions with respect to persons serving in the administration of NCTD as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President. The term administration in this rule must be considered in the context of Article 239 AA3 and Section 41 of the GNCTD Act. The executive administration by the Lieutenant Governor, in his discretion, can only extend to matters which fall outside the purview of the powers conferred on the Legislative Assembly, but it extends to powers or functions entrusted or delegated to him by the President, or in which he is required by or under law to act in his discretion or to exercise any judicial or quasi-judicial functions. The term administration cannot be understood as the entire administration of GNCTD. Otherwise, the purpose of giving powers to a constitutionally recognized and democratically elected government would be diluted. In a democratic form of government, the real power of administration must reside in the elected arm of the state, subject to the confines of the Constitution. A constitutionally entrenched and democratically elected government needs to have control over its administration. The administration comprises of several public officers who are posted in the services of a particular government, irrespective of whether or not that government was involved in their recruitment. For instance, an officer recruited by a particular government may serve on deputation with another government. If a democratically elected government is not provided with the power to control the officers posted within its domain, then the principle underlying the triple chain of collective responsibility would become redundant. That is to say, if the government is not able to control and hold to account the officers posted in its service, then its responsibility towards the legislature as well as the public is diluted. The principle of collective responsibility extends to the responsibility of officers, who in turn report to the ministers. If the officers stop reporting to the ministers or do not abide by their directions, the entire principle of collective responsibilities is affected. A democratically elected government can perform only when there is an awareness on the part of officers of the consequences which may ensue if they do not perform. If the officers feel that they are insulated from the control of the elected government which they are serving, then they become unaccountable or may not show commitment towards their performance. We have already held that the relationship between the Union and the NCTD resembles an asymmetric federal model, where the latter exercises its legislative and executive control in specified areas of the state list and concurrent list. Article 239 AA, which conferred a special status to NCTD and constitutionally entrenched a representative form of government, was incorporated in the Constitution in the spirit of federalism, with the aim that the residents of the capital city must have a voice in how they are to be governed. It is the responsibility of the government of the NCTD to give expression to the will of the people of Delhi who elected it. Therefore, the ideal conclusion would be that GNCTD ought to have control over services subject to exclusion of subjects which are out of its legislative domain. If services are excluded from its legislative and executive domain, the ministers and executives and the executive, who are charged with formulating policies in the territory of NCTD, would be excluded from controlling the civil service officers who implement such executive decisions. The legislative and executive power of NCTD over entry 41 shall not extend over to services related to public order, police, and land. However, legislative and executive power over services such as Indian administrative services or joint cadre services, which are relevant for the implementation of policies and the vision of NCTD in terms of day-to-day administration of the region, shall lie with the NCTD. Officers thereunder may be serving in NCTD even if they were not recruited by the NCTD. In such a scenario, it would be relevant to refer as an example to some of the rules which clearly demarcate the control of all India or joint cadre services between the union and the states. NCTD, similar to other states, also represents the representative form of government. The involvement of the Union of India in the administration of NCTD is limited by constitutional provisions, and any further expansion would be contrary to the constitutional scheme of governance. We reiterate that in light of Article 239AA and the 2018 Constitution Bench judgment, the Lieutenant Governor is bound by the aid and advice of the Council of Ministers of NCTD in relation to matters within the legislative scope of NCTD. As we have held that NCTD has legislative power over services, excluding public order, police, and land, under entry 41 list 2, the Lieutenant Governor shall be bound by the decisions of GNCTD on services as explained above. To clarify, any reference to Lieutenant Governor or over services, excluding services relating to public order, police, and land, in relevant rules, shall mean Lieutenant Governor acting on behalf of NCTD. Now, the conclusion. The division of administrative powers between the Union and the NCTD, as explained in this section, must be respected. In view of the discussion above, the following are our conclusions. A. There does not exist a homogeneous class of union territories with similar governance structures. B. NCTD is not similar to other union territories. By virtue of Article 239AA, NCTD is accorded a sui generis status, setting it apart from other union territories. C. The Legislative Assembly of NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries of List 2. In addition to the entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239AA 3A. D. The executive power of NCTD is coextensive with its legislative power, that is, it shall extend to all matters with respect to which it has the power to legislate. E. The Union of India has executive power only over the 3 entries in List 2, over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. G. The phrase insofar as any such matter is applicable to Union territories in Article 239AA3 cannot be read to further exclude the legislative power of NCTD over entries in the state list or concurrent list over and above those subjects which have been expressly excluded. H. With reference to the phrase subject to the provisions of this Constitution in Article 239AA3, the legislative power of NCTD is to be guided and not just limited by the broader principles and provisions of the Constitution. And I, NCTD, has legislative and executive power over services, that is entry 41 of list 2 of the 7th schedule, because 1. The definition of state under section 358 of the General Clauses Act 1897 applies to the term state in part 14 of the Constitution. Thus, part 14 is applicable to union territories. And 2. The exercise of rule-making power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. We have answered the issue referred to this Constitution bench by the order dated 6 May 2022. The registry shall place the papers of this appeal before the regular bench for disposal after obtaining the directions of the Chief Justice on the administrative side.